It's no surprise that businesses are going through a hard time. We are seeing liquidation numbers increasing across New Zealand. But what does that mean for your employment relationships? In this Ask Law Lenz episode, we will be tackling the question around what responsibilities an employer has when their business needs to permanently close down. Now, you'll be surprised because there's a lot of good faith and also a redundancy process that cannot be avoided. So stick around because we're going to get into all of the nitty-gritty on everything you need to know so that you're compliant during your business closure. Hi everyone, welcome back to Law Lenz. My name is Sanam and thank you so much for tuning in today. Look, it is crazy the numbers that we are seeing at the moment in terms of liquidations. And it was really interesting because I put a poll out and it's still running if you wanted to participate in it around what topics people are interested in and what they want to see in future out of Law Lenz. And one of the hot button areas was redundancy and restructures. It's because so many businesses are going through redundancies. They are going through permanent closures. And you may be wondering, what are we actually looking at? Is it that bad? Let me put it into perspective. Just the second quarter of 2024 alone, we have seen 629 companies go into liquidation. If we compared the second quarter of 2024 with the exact same second quarter of last year, we can see that there's been a 35% increase in the companies that have been removed from the register. So it's serious. During COVID, we saw mass business closures and many employers were put through the ringer, right? We saw them going to the employment courts, going to the Employment Relations Authority, dealing with these personal grievances. Now we're seeing that increasing costs like mortgages, insurance, utilities, they're affecting people's willingness to spend. And that's taking a toll on a lot of businesses across New Zealand, whether they're in retail, hospitality, tourism, you can definitely see it trickling across New Zealand. That's why I would say it's no surprise at all with everything that's happening that I got this question through the Law Lenz LinkedIn page. But I'm glad this question came in because at least someone with their ear to the ground has reached out and said, look, I want to see if you can have a chat about this because I know people around me that are going through this and they don't really understand their obligations. So when this person reached out, they were really actually genuinely concerned about the people that they knew maybe not doing business closures correctly. I wasn't surprised about it because I get it. I absolutely understand because one of the biggest objections I used to get when I worked in advisory was, but the business won't exist anymore. Why do I need to do any sort of process when I'm terminating these employees? I just need to let them know because there's not going to be any future work. What are they going to do? Come after me? And this is such a valid argument. I completely understand. But unfortunately, the law and the case law just does not align with that perspective. So we need to work with that, right? And the questions that actually came up was around what process does an employer have to follow if they are permanently closing down their business? And what does a consultation actually look like when we're talking about a small business? When we're looking at a small business consultation, you're not looking at hundreds of employees going through consultation processes. You might be looking at 3 or 4 employees, 2 or 3. What does that actually look like? And the last question was, when do you start having the conversation with your employees? These 3 questions are so critical to these processes, and I am so glad that this person reached out. So I really appreciate it. Thank you for taking the initiative, especially for people that you know that may not be doing the right process. Absolutely. When the person reached out to me, they said that it had to do with a misconception around what the process needs to be. And I 100% agree with that. The employer is usually in a situation where the business is no longer financially viable. And what happens in these cases is that you get a little bit desperate and you start looking at ways that you can cut corners. And it's not to say that all employers are like this or that this is what ends up happening, but it is a common theme, and it's because you are in a tricky situation. You're dealing with debtors and creditors and all these different things that this is the last thing on your mind. But that never negates from the requirement that you need to follow the law to the T. So today we're going to get into what all of that means, what the process looks like, what the law says about this particular area and permanent closures. But before we get into it, I just wanted to say, make sure that you follow the podcast and jump over and follow me on LinkedIn. I post regularly on LinkedIn with lots of employment law insights, key information. I'm all about helping employers, businesses, HR professionals get their employment practices in order. So So jump over, definitely give me a follow. And if not, follow the podcast because every week you get a brand spanking new episode. And trust me, they're worth listening to. If you don't believe me, stick around for this one and you'll see. All right, we'll get into what a permanent business closure actually is, because we're not talking about close downs here, right? We're talking about permanently closing your business. You are closing up shop, shutting up shop. You are moving away from owning that business. And generally what this means is that you've contacted IRD, you've canceled your GST registration, you're filing your final return and your final employer monthly schedule. And that's when IRD will officially deregister you as an employer. Now, that means that the doors have closed, that you are not running that business anymore, and that you no longer have employees. So it's not a temporary business closure where you're looking at maybe a month shutdown. It's a lot more permanent than that, as you can see. Now, I know that this circumstance, like I said earlier, makes it seem like, look, all you need to do is just pack up and move on. There is no requirements here because at the end of the day, there is no business for these employees to come back to. But one thing we learned from the COVID lockdowns and from the permanent closures that we saw coming out of COVID was that employers were not able to bypass the law. The law stood as is and the requirement stood as is, even though the employers were going through a financially difficult time, they were strapped for cash, the business was not viable, it still wasn't a reason. Now, I'm going to get into exactly what the law says because that's the most important thing. But you'll be surprised because what we're working off of is a little bit of legislation, but a lot of case law. Case law is what usually dictates this specific area because what you're going to be looking at, unfortunately, is redundancies because you are now no longer needing those roles. So we'll start off by looking at the law first. Of course, the Employment Relations Act, that is our go-to. Now, Section 4 of that act is what we need to look at. And funnily enough, like with many things that I discuss in this podcast, it comes back to good faith obligations. So you may be thinking, good faith obligations, what do I need to do there? How does that work in this case? Because we always talk about you need to be communicative and you need to make sure that you're not hiding anything or doing anything sneaky. But how does it actually work in this scenario? Under good faith obligations, what the law actually says is that any proposal from an employer that could adversely affect the employee's continuation of employment needs to be provided to the potentially affected employee with all of the information that is relevant to the proposal. And you need to also make sure that you provide the employee with a reasonable opportunity to comment on the proposal before a decision has been made. So what does that mean? That means being open to feedback and considering that feedback with an open mind. So you're not making any decisions. It's all about having clarity, open mind, not jumping to conclusions here. You may be thinking, Sanam, you are so naive. That is not how it works in business. And trust me, my friends, I understand that is not how it works. I understand that usually when you are at this stage, you are at your last resort. You are thinking, how else can I make this business function? This is the only thing I can do. I've tried everything. The way that the law is set out is that you can't be jumping to conclusions. If you know that this is the option that you want to go down, take it as an option. Do not take it as a definitive. So that's why it's all about being a proposal. It's all about putting it to the employee for feedback. Even though you may be thinking this is what's going to happen, just go in there thinking, look, this is what we're angling towards, but let me hear what you've got to say, rather than going in there saying, no, 100% this is what we're going to do, and that's that. Now, when we're talking about a proposal, when we're talking about adverse effects to the continuation of employment, it's starting to sound a little bit more like a redundancy, right? You need to have a redundancy process. When you're looking at what is a redundancy, it's not defined in the legislation. And that's why I say we need to go to case law, because cases are what generally refers to a situation where an employer makes the decision that a position has become superfluous to its business needs, and that the worker holding that position needs to be dismissed because there is no other suitable roles for that person in the business. I wanted to get into the cases first because I believe that this will back the positioning of why you need to go through these processes. Because it's one thing for me to sit here and say, no, you should do these processes. It's a requirement. So I wanted to get into a couple of employment relations authority cases. And the first one is actually one where an employee clerk and Glitz and Glam Hair and Beauty Limited dealt with the case, which all stemmed from November 2021, but the case was finally heard in 2023. So this is the message that the owner of a salon, the employer, sent to their employee clerk, and it was via Facebook Messenger. I'm I'm writing to inform you that sadly we are forced to close the business down and discontinue operation as of the 3rd of December. We are absolutely devastated and we are without jobs, but also not employable. I'm navigating my way through all the processes I have to take with closure. Hope you're feeling better and we will be in touch. What happened in this case was a little bit more extreme. Yes, process was not followed and we'll get into that, but also Glitz and Glam never paid the employee their final pay or their notice period, any entitlements or anything that came along with that. And that really added to the case. The authorities said that first thing we need to do with any situation like this, where somebody's doing a permanent closure of their business, is we need to see if the redundancy was genuine, because it still needs to be a redundancy. So was there a genuine business reason behind that? And usually what you would need to show is your financial positioning, because this can be easily backed up. Generally, an employer can show that, yes, this is what they've gone through. This is the downturn in business that they've experienced. In this particular case with Glitz and Glam, the financial information was only provided after the decision was made, saying to the employee, look, we're strapped for cash, we're in a financially bad situation, we're shutting down, and that's letting the employee know that this is exactly what we're doing. But there wasn't any consultation process. What the authority said was that, yes, absolutely, like in many of these cases, and keep that in mind, like in many of these cases, there was a legitimate collapse of a business, and it is a genuine reason behind that redundancy. But there is still a statutory obligation to follow a fair process when it comes to making employees redundant. According to your good faith obligations, you still need to follow a process when it adversely affects the continuation of the employee's employment. So what happened in this particular case was that the Employment Relations Authority said that a fair and reasonable employer, when making employees redundant, even when there was a genuine business reason, would be expected to provide information and to consult with its employees before any final decisions were made. What it also said as well was that the employee should have been given information about what was happening with the business and that there was a likelihood of redundancy with an opportunity to respond prior to any final decisions being made. What does that mean? I think this is a clear indication of timing. What the authority is saying here is that before any decision's been made, before you get to that stage where you're like 100%, I am closing my doors, before you get there, you need to make sure that you have given the employee the information that they need about what's happening in the business, everything that you've been trying to do, trying to navigate, and that there is a high chance that redundancy will be on the table. And you need to give the employee the opportunity to respond to that. And you may be wondering how serious these situations are, right? Because a default in process is not the same as causing severe burnout to somebody in the workplace. When it came to this, the authority said that failure to follow due process in redundancy situations was more than a minor defect in process, and it resulted in the employee actually being treated unfairly. Well, this case is from a few years ago, and we know that compensation amounts have gone up. But just from this case, the authority looked at almost identical cases and said that because it was procedurally flawed, the proper remedy in this case would be awarding the employee $15,000. I know. Think about being in that situation and then having to fork out $15,000 when you're that strapped for cash. Another case dealing with a company called KNCC Limited. That case in 2023 also had a very similar justification behind it. In this case, what was happening was that the company had multiple construction sites, and it just so happened that they were closing one particular site down because of the financial situation they were in. And so KNCC Limited decided to close down that site. But what the authority said was that in terms of substantive justification, although the construction site that the employee normally worked on had been temporarily closed, they had not received any restructuring proposal, and there had been no consultation with the employee regarding a possible redundancy or about possible redeployment opportunities. And again, in this case, the employer was ordered to pay $27,000 in lost wages and distress compensation, and $5,000 for contractual breach. I remember a long time ago, I dealt with an employer that unfortunately made an employee redundant. So this particular employer wasn't paying their employee, made them redundant on the spot by just sending them a text message. And effectively, they kept saying to me, oh, well, I'll just leave the country, or I'll just shut up my business. And what can they do? They can't come after me. Well, I wanted to get into that because I wanted to talk about how an employer can be held liable, because a lot of times the perception is if my business closes, I won't be held liable. But if you're in liquidation, if your business has closed down, you can still have an employee coming after you. And it's even more risky when you're closing a business and you've done it incorrectly, because you can have multiple personal grievances at the same time. I've seen it, I've dealt with it, where we would have maybe 6 employees, 7 employees at one time doing these PGs. And it's really important to make sure that you understand the severity of the case. In terms of how an employer can be held liable, first things first is breach of contract. Depending on what's actually in your contract, an employer could be held liable and could have to pay up to $10,000 for each breach. If you had some clause in there around good faith or around consultation or anything under the sun around all of that, and it could be in a broader sense, it could be specifically related to redundancies and restructures. If you've breached that, then that's up to $10,000 personally that you have to pay. So in liquidation situations as well, you see the same thing where salaries and wages, they still need to be paid. That still needs to go through its process. So it's really important that employers understand that it's not just a matter of stepping away and walking away. You may be wondering what the process looks like. And the process is really similar to any other scenario when you're looking at a redundancy situation. But I would say that here, there are slightly less steps than a normal situation where maybe you'd be doing a selection criteria. So let's get into all of the steps that you need to look at. The first thing is make sure that you have really exhausted all options. A redundancy of any role, it doesn't matter if you're doing it and you have 10 employees left or if you're doing a permanent closure, it is a last resort measure. And last resort can mean something different for each person. But we know that what it usually means is that you have tried everything possible to make the business viable and it's just not working. And they aren't kicking off any kind of process yet, but it seems like this is what they're moving towards. If you are in that position, then that's when you need to start having a look at having these conversations. The second one is that I really dislike, and I think from an ethical standpoint, as well as what's in case law as well, we've seen that completely out of the blue is not okay. I know that it is already coming out of the blue, but to have it completely out of the blue in writing is just not ethically right. It is always best from an ethical perspective to ensure that you're not raising anything in writing where all of a sudden employees are going to get their backs up and they're really worried about what's going on. Instead, it would be having a chat to all of these affected employees. And an employer generally will need to let them know that, look, this is the position that we're in. This is exactly what's been happening. This is what we've been trying to do, but unfortunately, it's just not going well. And from my experience, a lot of these employees know that something's happening. When you're not dealing with a large corporation with 5,000 employees and you're dealing with a small mom and pop business, and you're looking at maybe 4 employees, 3 employees, they all know the business really well and they can see the ebbs and flows of business. They can also see what the employers are going through. So keep that in mind as well. Now, the next stage is that you're going to be telling them in that chat where you're notifying everyone that you're going to be sending them a proposal. And this proposal is basically your case that you are setting out to let the employee know about everything that's backing up why you need to permanently close the business. Your genuine business need to restructure, what you have done to try and stop a redundancy proposal from coming in front of these employees effectively. And that means actually listing out what you've tried to do, right? So if you've applied for certain loans, it's really important to lay this out. And also, it's important to say what that means for the business and the employees if you are looking at a redundancy proposal. So it's really important to keep that messaging really clear and keep it as a proposal. No decisions have been made. So it's proposed outcome. We are looking at potential redundancy. We are looking at different options and we would like your feedback. Now, in terms of the proposal, generally what's good is if there are more facts. The more facts, the better. Things like a downturn in business and examples where there's a dollar figure of any losses and a comparison of where the business was and where it is now. And keep in mind that if an employee requests this information or this evidence, then the employer may need to show this proof, especially if you're dealing with a personal grievance situation, because when you're at an authority investigations meeting, you're going to try to give them all of this information, right, to help your case. Also having a look at redeployment opportunities. What do you mean by redeployment? Because we're doing a business closure and there's nothing else. But the reason why I wanted to squeeze this one in there is that if you've got other opportunities, so for example, that the employee can work in another premises or maybe another business that you own, then you may want to consider that as well. And once redeployment options have actually been identified, then the employee should be offered any role which they have the relevant skills and experience to perform, or anything that they can be reasonably trained to do. So they need to be offered that. It's not a matter of saying to them, hey, would you like to apply? It's a direct offering of that particular role. I used to deal with this a lot when I was advising for the hospitality sector. There are a lot of businesses out there where there's a parent company that owns a lot of subsidiaries, or subsidiaries sit under them, and it's because the owners or the employers will have multiple cafes or multiple restaurants. So it's really important to have a look at that. And it's a contentious area, but what we can see is that if the employer has the ability to take on the employee at another premises, then they need to look at that as a viable redeployment option. So with the proposal, you will also have a letter. So this is the next step-ish, I guess you can say, because it comes in with the proposal as well. But you would have a letter that invites the employee to a meeting, and you would be holding that meeting. It's very clearly laid out that you want to have a meeting with the employee to discuss their feedback regarding the proposal, that the company mentions in there that they are proposing to make that role redundant or disestablish that role. So that's why in that letter, it's really critical to ask if the employee would like to bring a support person or representative. And it should be detailed in the letter. It doesn't need to be onerous, just a line. With that said, sometimes it's hard for them to find a representative over a weekend. So you're looking at having a chat to the employee, sending them the proposal and the letter, giving them 2 to 3 working days. And the reason why I say 2 to 3 working days is because for a permanent business closure, a lot of people are not redeploying. But if you are redeploying, and that's something that you are considering, let's say you've got other sites or another business they can move into, then 4 to 5 days, working days, is actually the reasonable amount. It solely depends on how long reasonably it would take for somebody to really consider this, a longer time for the employee to mull everything over. So that's why that 4 to 5 days is there. Otherwise, 2 to 3 days is perfectly fine, and 2 to 3 working days, keep that in mind as well. So when you are in this meeting with the employee, you've invited them now, given them those 2 to 3 working days, they've now come to the meeting. It's really important for the employer in this case to get the employee's feedback. The employer doesn't need to really weigh in here unless the employee asks for further information. I always say to employers, especially small employers, if you feel uncomfortable with answering something, you don't have to. No one is holding your feet to the fire. No one is saying anything to you where you need to answer straight away unless you feel comfortable doing that. Make sure you keep a note of the meeting and send that off to the employee. It's always good for everyone to be on the same page about what was discussed in the meeting rather than it coming up maybe later on down the track where the employee says, no, I never said that. The next stage is to consider the feedback. Everyone wants to know how long is needed to consider feedback. I know some people have turned around and said, can't I just deliver the decision after an hour or just by the afternoon? It's really important here to take some time. If there is no feedback from the employee, then it makes sense for you to come back relatively quickly. But if the employee has provided feedback, then give it at least 2 days, right? Give it at least 2 days to think about what the feedback is. And if they have provided feedback that needs a response to that feedback, it's really important that you give them the time of day and that an employer responds to their employees' feedback. Now, the last stage and the last step in the process is to deliver the outcome. An employer needs to be clear about what is actually happening in the process. It's really important for employers to deliver a clear outcome that specifies how the employment is ending, the fact that it was a redundancy, and that the employee will either be paid in lieu of notice if the contract allows for that, or if they need to work out their notice, and what their last day of employment will be, and what their entitlements are, when they're going to get that. And once you lay that all out and you let the employee know very clearly in that letter that they've been made redundant, this ties off the process. Now you are done. Generally, with this kind of situation, if you are making somebody redundant and you are terminating them, I would always suggest to do it in person. It's out of courtesy as well. So these are my top tips and my summary of what you really need to focus on as an employer. It's really important that you lay this all out and you keep it as a proposal. It's all proposed. No decisions have been made. You are trying to get their feedback. And then the next one would be the proposal needing to be very detailed. You need to make sure that proposal is not generic. It is really not the way to go about it. It should have lots of information so that it provides clarity about the situation. Never predetermine the outcome. It's easy to do this, and like I said, you're in a pressurized situation. It's easy to say that this is what I want to do, but good faith requirements means that you need to keep an open mind. Now, the last thing that I wanted to leave with and close off with was that I saw a lot of cases around the fact that the employer said, I'm closing down the business, and then they chose not to pay out any entitlements or the last set of wages that was owed to the employees or anything like that. And I'm not saying that this is a common theme, but it seems like with a lot of these cases, what pushes the employee to raise that personal grievance is because they haven't received their entitlements, they haven't received anything that's owing to them, and they have not received their final pay with the last amount of wages in there. So just keep that in mind when you're looking at the process. But I hope that this has answered the question of the person that asked this. I know that this was a lengthy episode and quite detailed, but this is one of those ones where it is a misconception. And if you have any questions like this person did, then please absolutely reach out to the Ask Law Lenz email or go ahead and reach out to me on LinkedIn. More than happy to chat. And I'm happy to keep all of these things anonymous. Well, thank you so much, everyone. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.